Talk Shoe. Recorded live.
Welcome, everybody, to our regularly scheduled Wednesday night call. This is Matthew. I am the moderator, and we have special guest Christian Walters on tonight, and we are continuing a discussion on trusts. Before we get started, I'm reading our disclaimer. Notice and acknowledgement and agreement. This show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, I would like to formally turn it over to Christian Walters so we can jump right in tonight. Christian?
Okay. Thank you, Matt.
Absolutely. You're welcome.
Like Matt said, we're in the Gilbert's Law Summaries book on trusts, and we're on Chapter 3 on page 100, Section C, under the creation of testamentary trusts. Number 1, Requirements of Wills Act and Supplementary Doctrines, Section 354. A testamentary trust is one created by the will of a decedent. This will, and any codicils, plus other evidence that satisfies the Wills Act, must provide the essential elements of a trust. That is, the trust res, the beneficiaries, and the trust purpose must be ascertainable from the will or established in some other manner in compliance with the Wills Act requirement and related doctrine. However, the trust purposes may be inferred from an ascertainable interest of the beneficiaries, and the trustee will be supplied by the court if necessary. A more modern view calls for application of the rule of harmless error or substantial compliance in determining the validity of the will, which would permit a court to dispense with one or more statutory formalities, even if they have not been followed, so long as the proponents of the document established by clear and convincing evidence that the testator intended that the writing constitute her will. See Restatements, the third, Section 17, Comment B, and Restatement of the third of Property, Section 3.3, and the UPC, Section 2-503. A. Sources, Section 355. Thus, in addition to properly executed, that is, attested or in some states holographic or in a few states even non-capacitive or oral, wills and codicils, trust terms, typically beneficiaries, may be provided through the doctrines of facts of independent significance and incorporated by reference. See Wills Summary and see Infra Section 369 through 374. Example, independent significance. Carolyn Gerard bequeaths to Henry Axford in trust for person who, in Henry's opinion, has given him the best care in my declining years. Under this standard, objective evidence of acts or events that has had significance apart from their efforts on the will can serve to identify the beneficiary, even if the trustee fails to make a selection. See Moss versus Oxford, Supra at Section 192. Example, incorporation. On June 3rd, Walden executes a will bequeathing to the Toledo Trust Company in trust for persons and purposes set out in the writing dated June 1st and kept in my safe, unquote. Assuming the writing conforms did in fact exist, then the will was executed. and otherwise meets the particular state requirements for incorporation, and assuming the doctrine is recognized in the state, the trust terms may be supplied by the described writing. And now, creation of trust, inter vivos trust versus testamentary trust. When created under inter vivos during the settler's life, testamentary trust by settler's will. And under inter vivos trust, the requirements: effective present transfer, that is, delivery to trustee, of res or present declaration of trust. And under testamentary trust, the essential elements of the trust, res, beneficiaries, and purpose must be ascertainable from the will or codicil by any other method allowed by the Wills Act. Example, facts of independent significance, incorporation by reference. Now the inter vivos trust requirements: no notice to trustee or beneficiary required. And under the inter vivos trust, under the requirements, no writing required except for trust of real property. Page 102, number 2, secret trusts. Oral trust of outright bequeast or divisee, section 356. Numerous cases have arisen where a decedent made a will leaving property to a particular divisee or litigantee, relying upon the person's oral promise to hold property in trust for others. Because the will itself says nothing about a trust, the oral agreement is often referred to as a secret trust. The agreement as such is clearly unenforceable under the Wills Act and related doctrines and amounts to an attempted testamentary disposition of the equitable interest without the required formalities. Example, testator's divisee's Black Acre outright, so far as one can tell from the will, to a friend, relying on an oral agreement with the friend that the property will be held in trust for testator's child. A, may be voluntarily performed, section 357. If the divisee or legatee or the friend voluntarily performs as agreed, no one can complain. B, constructive trust remedy, section 358. If the divisee or litigantee refuses to perform, the oral agreement cannot be enforced directly as an express trust, but it well settled in most states that the divisee or legatee will not be permitted to retain the property outright in breach of oral promise to the testator. Consequently, constructive trust is imposed in favor of the person or persons for whom the property was agreed to be held in order to avoid unjust enrichment of the divisee. In a case cite here, Olson versus First National Bank, 1957, and also see the restatement of the third, section 18, subparent 1. The rule applies to land as well as to personal property. And under Briggs versus Richardson, 1979 South Carolina case, a minority of states would confine the remedy to instances of actual fraud, duress, undue influence, and abuse of confidential relationship. And over Flauf and Flauf, Ohio, 1967, also under certain circumstances in a few states, Dead Man's Acts, which prevent testimony to personal transactions or communications with the deceased when offered against the representative or successors in interest for the deceased. See the evidence summary, which may present obstacles to enforce. And see Campos versus Magnuson, Illinois, 1987 case. Number 1, rationale. Because the statute of wills does not apply to trust created by operation of law, a constructive trust can be enforced even though the express trust cannot. Number 2, no requirement of fraud, etc., section 359. The general view is that a constructive trust will be imposed in this situation for mere breach of promise, whether or not the divisee or legatee was guilty of any fraud, breach of confidence, etc. A, distinguished from statutes of frauds cases, section 360. The general view above is different from the view of many states involving oral trust agreements that are unenforceable under statute of frauds. That is, that no constructive trust will be imposed on the absence of fraud, mistake, breach of confidence, etc. See SUPRA section 327 through 346. There appears to be no real justification for the distinction, which is another reason why the widespread rule of the statutes of frauds cases is often criticized and increasingly being rejected. Number 3, no requirement that divisee induced gift, Section 361. It is not necessary that, in the above example, friend's promise or agreement be shown to have actually induced the divisee from testator. It needed only appear that the friend knew that it was testator's intention by friend hold in trust for another. Friend is deemed to have expressly or impliedly accepted the gift upon intended trust. See the restatement of the 3rd, Section 18, subparent 1, comment B. It is immaterial that friend was notified of testator's intent after execution of the will, as long as the knowledge was received before testator's death. If friend had refused, testator could have revoked the request or bequest to divisee to friend and left the property to someone else who would agree to carry out the trust. And see Olson versus First National Bank, Supra. Section 4, for whom constructive trust imposed, Section 362. As mentioned above, most courts granted remedy in these cases, and most of the courts raised the constructive trust in favor of the intended beneficiary or the testator's child, rather than that of the estate for the settlor or the testator. The rationale is that the injury flowing from the divisee or legatee's breach of promise is primarily to the intended beneficiary rather than the testator's estate. And see Weisstein versus Moores, 1929 case, and see restatement of the 3rd, Section 18. A few of the cases that grant a remedy, however, have held that the constructive trust is raised in favor of the testator's estate, and the property therefore goes to the testator's residuary divisees, or, if none, to the testator's intestate heirs. The court's reasoning that enforcing the trust for the intended beneficiary benefit would circumvent the Wills Act by building a parole trust upon an absolute bequeathed or divisee. A. Criticism. The objections to this result are essential those stated in the statute of frauds discussion, see Supra Section 342 through 346, and particularly to give the property to others that then testator's child would itself result in unjust enrichment of those others. Exam tip. Keep in mind that a constructive trust will be imposed in the case of secret trust, even if the divisee or legatee did not make the provisions until after the will was executed. Furthermore, it does not matter whether the divisee or legatee intended to perform the promise when he made it. All that matters is that the testator relied on the promise in executing or not revoking the will. C. Distinguished. Semi-secret trust. Section 363. If the decedent's will indicates that the property was being devised into someone in trust, but the trust is incomplete and thus defective because the beneficiary was not designated, example, a divisee to trustee in trust for persons and purposes agreed between us during my lifetime, or simply to trustee in trust, the cases are split as to the result. 1. Majority view. Resulting trust. Section 364. Many courts have held that the named trustee holds upon the resulting trust for the testator's heirs or residuary beneficiaries on the ground that it is simply an attempted testamentary trust, the equitable interest in which has failed. A resulting trust is the appropriate result of a wholly or partially invalid trust, that is, where it is clear from the will that the divisee took a non-beneficial legal title, and trust fails to dispose of the equitable interest. See Infra Section 1011 through 1020. Under this view, it is immaterial whether the trustee wishes to perform the trust. The resulting trust is imposed even where a trustee acknowledges the oral trust and seeks to perform it. The Oliphie versus Wells, Massachusetts case, 1881. And because on the face of the will there is a trust that is defective, there is no possibility of the transferee being unjustly enriched, and thus no need to intervene in the constructive trust on that ground. A. Criticism. If no word of trust has been used, a constructive trust could have been imposed for the intended beneficiary, see above, despite a risk of the trustee being an innocent intended beneficial divisee, but because the will contained words of trust, and it was therefore obvious on the face of the will that some trust was involved. Ironically, the intended beneficiary can offer no evidence unless of fraud, etc., even to clarify a patent uncertainty. Thus, the intended beneficiary gets nothing and the property reverts to testator's estate. In this situation, the settler's intent is frustrated because he used words of trust in the will. B. Response. The theory advanced in support of the distinction between the secret and semi-secret trust is that in the former, where the words of the will appear to create an absolute gift, the secret trust case, the testator's heir are not intended to benefit in any event because the will clearly takes the property away from them. The question then is simply whether the transferee should be allowed to keep the property outright or be forced to hold in trust for the intended beneficiary, the latter being chosen to avoid the transferee's unjust enrichment. But where words of trust are used in conjunction with the transferee's gift, the semi-secret trust case, it is clear that the transferee was not meant to take the property outright. Because no effective gift has been made of the equitable title, there is no need for the court to receive evidence of the true intent, given the risk that such evidence would entail. Therefore, the property must be held by the transferee of testator's heirs, a simple, routine application of a resulting trust doctrine. Any other disposition violates the purpose of the statutes of wills without justification, for there is now no risk of the transferee's unjust enrichment. 2. Minority view. Constructive trust. Section 365. Accepting the above criticism as valid, a number of courts have imposed a constructive trust for the intended beneficiary, also the preferred view of most commentators. The rationale, if a constructive trust can be imposed where no words of trust appear in the will, there is no logical reason why one cannot prove a part of the trust, that is, the names of the beneficiaries or the terms of the trust, where the trust intent is expressed in the will and the only remaining part of the trust is missing. This is the restatement position, emphasizing prevention of unjust enrichment of testator or others, successors in interest, that there is not even the unusual risk of spurious claims against the divisee or might have been intended to take beneficiary. See Sears versus Rule, 1945 California case, and the restatement, the third, section 18, comment C. D. Distinguished. Breach of agreement by intestate heir, section 366. The secret trust principles applied in cases where the decedent died intestate, foregoing the opportunity to make a will in reliance on promise by an heir to hold the property in trust for another. See restatement the third, section 18, subparent 2. In this situation, some courts require compelling evidence of the decedent's reliance on the heir's promise or acquiescence, inducing the decedent not to make the will. Now, secret and semi-trust testamentary trust compared. Secret trust, absolute gift and will, that is, no indication of trust made in reliance on the divisee's or litigatee's promise to hold the property in trust for another. Versus semi-secret trust, gift and will to a person in trust, but no trust beneficiary names. And now the secret trust, divisee or legatee may perform trust if she chooses, and under the semi-secret trust, divisee or legatee cannot perform trust. Under the secret trust, if divisee or legatee refuses to perform constructive trust imposed in favor of intended beneficiary. In the semi-secret trust, the majority view, trustee holds all on resulting trust for testator's residuary legatees or heirs. The minority view, constructive trust imposed in favor of intended beneficiaries. Page 106. Number 3, pour over wills, testamentary additions to inter vivos trust, section 367. A pour over disposition in an attempted testamentary gift to a pre-existing trust, that is, an attempt to have some or all assets of a decedent's estate added to the corpus of the trust, which she or another created during her lifetime. Example, testator creates a valid inter vivos trust, and the latter executes a will dividing her residuary estate to the trustee of her inter vivos trust, on trust for previously declared by me, or to be held, administered, and distributed as part of a trust established by me on such and such a date. A. Problem regarding validity, section 368. Is a pour-over provision in the decedent's will invalid because of the terms governing the administration and distribution of the estate assets, are not set out in a duly executed will, but only in an inter vivos trust instrument, which is not executed with the required Wills Act's formalities, or which, even if were so executed, may be said to lack the required testamentary intent. Although the validity of the pour-over gifts to inter vivos trust was at one time questionable, such gifts generally have been sustained under various theories and are now widely accepted under the Uniform Testamentary Additions to Trust Act, see Infra Section 394. B. Possible theories for sustaining pour-overs. 1. Doctrine of incorporation by reference, Section 369. A will may incorporate by reference the contents of a pre-existing document or other writings. Here, the inter vivos trust instrument. See Will Summary. A. Requirements, Section 370. The requirements for incorporating an extrinsic writing by reference are generally said to be: 1. The writing must be in fact in existence when the will, or via republication, when the last codicil to the will is executed. And 2. The will must refer to the writing as being in existence at that time. And 3. The intent to incorporate must appear in the wills. And 4. The extrinsic writing must be identified with reasonable certainty and must conform to the description in the will. Note: different courts may use different terms for the above requirements and may apply them strictly or leniently. B. Effect, 371, Section 371. Under this doctrine, if literally applied, there would appear to be two trusts: the inter vivos trust as originally constituted and a testamentary trust of identical incorporated terms holding the assets passing under the will. Because of incorporation by reference merely treats the pre-existing writing as if it had been set out in the will. However, courts allowing pour-overs either do not use the trust. See Wells Fargo Bank versus Union Trust Company versus Superior Court, a California 1948 case, or do not take it literally, holding that only one trust, an inter vivos trust, exists. And now the checklist requirements for incorporation by reference. To incorporate the terms of an extrinsic writing into a will, the following must be satisfied. 1. The writing must have been in existence at the time the will was executed. 2. The will must refer to the writing as being in existence at that time. And 3. The will must show the testator's intent to incorporate the terms of the writing. And 4. The writing must be clearly identified and described and conform to that description. 2. The doctrine of facts of independent significance, Section 372. The testator may reference to some extrinsic, non-testamentary act, event, or other fact, here the inter vivos trust, to identify the beneficiaries or terms of disposition in trust. Again, see the will summary. A. Now the requirements, Section 373. The general nature of the requirements for the act or event that may be filled in the terms or otherwise affect the meaning of the will are that it must not appear that the testator was simply attempting to avoid the formal demands of the statutes of wills, and that act, an event, or fact referred to have been a substantially significant part of the effect on property passing under the will. Example: testator's will devises her residuary estate in trust for those persons who are my full-time employees at the time of my death. The divisee is valid because the act hiring of or firing employees is normally done for a business purpose and not to designate beneficiaries of a trust. Number 1, note: unlike the doctrine for incorporating an extrinsic writing by reference above, the independent significant doctrine contains no requirements that matters reference to the predated and execution of the will or the codicil. In fact, references to future events and situations are usually fundamental to achieving the doctrine's purpose and social unity. It provides the adaptability and responsiveness of ambulatory documents, which a will is supposed to be. See example, the full-time employee example at the end of the preceding paragraph, and even such a basic and unquestioned form of designating, quote, my grandchild living at my death, unquote, as legatees. B. Effect 374. Under this theory, there is a single trust, both of the original trust assets and those added by will. The trust instrument is not incorporated into the will. Rather, the will disposes of the estate to the existing trust as a distinct and independent entity, much like a bequest to a corporation. See Wells Fargo Bank and Union Trust Company versus Superior Court, Supra. Exam tip. The most important thing to remember when analyzing the validity of non-testamentary acts is that there must have been significance apart from their effect on the testator's will. Although the resulting effect of the non-testamentary act or event designates a beneficiary or disposes of certain property, the effect must be merely incidental and independent of the act. C. Application. Pour over to non-modifiable living trust, Section 375. There should be no problem sustaining the pour-over provision in a jurisdiction that recognizes incorporation by reference as long as the interviewer's trust was, number one, in existence at the time the decedent executed the will, and number two, was by its terms irrevocable and unamendable. See Henry Ranch's will, that's a New York case, 1932. Number one, rationale. Such a trust, assuming it is expressed in writing, readily meets all the requirements of incorporation doctrine. See Supra Section 370. Even in jurisdictions that insist upon strict adherence to the requirements. Although some cases show confusion on the point, Clark versus Citizens National Bank, New Jersey case 1955, it is the trust instrument, not the trust, that is incorporated. That is, it is the writing, not the trust, which might still be unfunded. That must be in existence, thus, if the will's execution and the trust execution and the actual funding are handled in the same transaction, and if both instruments have been prepared prior to the final steps, as is often the practice, the precise order of events should not matter. However, it is not prudent without a pour-over statute, infra, to assume that all courts will recognize this. 2. Note, there should be no need to rely on the independent significance doctrine, although it would not be inappropriate, unless the trust is not evidenced by a writing, as could be the case of the res, if the res is the personal property. D. Application. Pour over to amenable trust, Section 376. Considerable difficulty has been encountered in a case of inter vivos trusts that are subject to revocation or amendment between the date of the execution of the will and the date of the testator's death. Number one, date to which reference is made, Section 377. Even though the trust is subject to amendment, if the pour-over reference is the terms of the trust and they exist at the date of the will's execution, the requirements of incorporation by reference pose no problem, and thus the writing as of the date can be effectively incorporated. Unfortunately, this is rarely the intention of the testator. Thus, the more significant and common problems discussed hereafter assume a reference to the terms of the living trust as that exist at the date of the testator's death. 2. Where the testator/settler power to amend not exercised, Section 378. Where an inter vivos trust was subject to revocation and amendment, but was not in fact revoked or amended between the execution of the will and the testator's death, the validity of the attempted pour-over depends upon the strictness of the court's application of the incorporation doctrine. Technically, what courts have sometimes called language of futility violates the second of the requirements stated above. See Supra Section 370. Because the stated intention to incorporate does not refer solely to the document already in existence. On the other hand, in some states, the mere fact that an unamended trust could have been modified or revoked has been disregarded and the pour-over gift upheld. See Henry York's Estate, New Hampshire case 1949. 3. Where testator or settler's power to amend is exercised, Section 379. Authority is also divided on the validity of the pour-over where the decedent did in fact amend the trust after the execution of the will. The issue is both the ability of the amendment and to affect the terms of the intended testamentary addition and to the overall validity of the pour-over. A. Application of incorporation by reference theory. Number 1, republication. Section 380. The first question to consider is whether there is a codicil to the will effective after the amendment or the last amendment, if there were several, to the trust. If so, the codicil should be deemed to have been republished, the will, under the doctrine of republication by codicil. See will summary. A will is deemed to speak again as if it were re-executed at the date of the codicil. The limited amount of existing authority on points given effect to the incorporation of the terms of the living trust, including the amendments as of the date of the codicil. The language of the futurity problem, however, could still cause problems in a strict jurisdiction. Number 2, no republication, Section 381. In the absence of republication of the will, different positions could have been and have been taken by courts. A, attempted pour-over fails, Section 382. Some courts hold that the attempted pour-over is entirely defective under the doctrine of incorporation by reference. The doctrine permits only incorporation of the instrument that was in existence when the will was executed. Because the amendments were made after the will was executed, the intended disposition cannot be sustained and the pour-over fails in its entirety. See President and Directors of Manhattan Company versus Janowitz, 1940 case. B, pour-over to unamended trust, Section 383. Other courts have upheld the attempted testamentary additions to the trust, but only as it existed at the time the will was executed. Only the terms of the living trust at the date could be incorporated by reference as pre-existing writings. Thus, the subsequent amendments must be disregarded under the incorporation by reference rationale. Number 1, criticism. Even if the court is prepared to overlook the problem posed by language of futurity, however, the results has been criticized as running a risk of thwarting the testator's true intention. She may have changed her mind and sought to terminate or limit the beneficiary's interest or add new beneficiaries and provisions that were important to her. Therefore, critics would prefer to have the pour-over fail entirely and the property pass under the residuary clause of the will or by intestacy. See President versus Directors of Manhattan Company, Janowitz, Supra. Obviously, the court would be open to either result and permit the pour-over in accordance with the pre-existing trust terms if it concluded that this would more nearly approximate the testator's probable intention, but invalidate the disposition entirely if it reached the opposite conclusion. B, more complete solution, application of independent significance doctrine, Section 384. Because the doctrine of facts of independent significance does not limit the reference to pre-existing facts, this doctrine, if appropriate, would offer a complete solution and allow the pour-over exactly as intended. That is, to the trust as they exist on the date of death, including amendments. The cases, however, are divided on the doctrine's appropriateness to pour-overs. Number 1, rejection of the doctrine, Section 385. Although many cases have simply overlooked the doctrine, several have rejected it on the grounds that repeated exercises of power to amend eliminated all independent significance that might have attached to the trust indenture. See President and Directors of Manhattan Company versus Janowitz, Supra again. Or on the grounds that independent significance really means something more like ordinary course of one's affairs rather than acts that arise solely out of the bounty-giving violation of the testator. See Atwood versus Rode, a First Circuit 1921 case. Number 2, modern trend, Section 386. The trend of authority, however, recognizes the amendment has an independent, non-testamentary significance in its effects on the disposition of the assets in living trust, and as a result, least of those assets, therefore the independent effect are substantial. The doctrine allows the amendment also to affect the testamentary disposition. Thus, the pour-over is sustained exactly as written, with the assets added to the trust as amended. See Canal National Bank versus Chapman, 1961 case, and Second Bank State Street Trust Company versus Pinion, Massachusetts, 1960. And see the restatement of the third, Section 19. the latter being lenient in recognition of the success of the Uniform Testamentary Additions to Trust Act, see infra section 394, and by an analogy, the acceptance of a harmless error or substantial compliance standards in wills law, see supra section 354. C. Trust revoked, section 387. Under the doctrine of independent significance, the revocation of the inter vivos trust can and probably ordinarily would have the effect of revoking the pour-over disposition. Even here, the revocation for reasons not suggesting a desire to eliminate the testamentary trust, but, example, in immediate need for funds, at least arguably should be disregarded as a fact to which the testator has not intended to refer. On the other hand, under the doctrine of incorporation by reference, a court could ignore the words of futurity and ignore the subsequent amendment, treating the original instrument as having been incorporated into the will with no revocation in a manner allowed by the Wills Act. Thus, under incorporation by reference, the whole array of alternativeness previously discussed would seem to be open to the court. E. Application, pour over to trust created by third party, section 388. Although there is little authority in this area, it would seem to be that the same principles discussed above should apply to provisions in the decedent's will seeking to pour testamentary assets into a trust, either inter vivos or testamentary, created by some third party. In fact, some objections to the use of the independent significance in this context as merely being part of the testator's own bounty-giving activities would seem less forceful here. Thus, the situation that usually occurs when both spouses wish to set up one or more similar trusts in their wills, but eventually wish the trust to be combined rather than to have two trusts or set up two trusts. Example, wife wishes to divise at least some of her estate to the husband, but if he predeceases her, to give her assets to the testamentary trust created in his will, and vice versa. One can expect a modern court to sustain the pour-over in such situations. What happens, however, if the predeceasing spouse revokes or modifies his will prior to the death, and yet the surviving spouse makes no change to reflect the change in the predeceasing spouse's will, leaving no actual trust under that will into which to make the pour-over? The result depends on the theory chosen by the court, much as the situation in which the trust itself was revoked. Number 1, incorporation by reference, section 389. Under this approach, revocation of the will by the first decedent is irrelevant, and the will of the second to die could well be deemed to have incorporated the provisions of the trust in the other's will as they existed at the time of the execution. Again, properly, if both doctrines were in existence at the time of execution, it should not matter in which order they were executed. The pour-over could be given effect accordingly. On the other hand, as indicated above, various objections could be raised to the use of incorporation by reference in this case because of the possibility of and the attempted reference to future writings unless the reference was to the other's will of a specific date or to an inter vivos trust created by the other solely in accordance with the terms as they exist at the time of execution of the surviving spouse's will. Number 2, facts of independent significance, section 390. Here again, unless the reference to the third party's trust expressly or impliedly excludes acts of revocation, generally the acts of revocation would be recognized as a fact having significance apart from its effect on the disposition of the present testator's estate. Thus, revocation of the third party's inter vivos or testamentary trust provisions would revoke the pour-over provisions of the testator in question, and that property would then pass either by residuary clause of the will or by intestate succession. Number 3, modification after testator's death, section 391. The problem exists where the testator divises property to the inter vivos trust created by a third person who outlives the testator and modifies the trust after the testator's death, although there is little authority on the point. The result, again, seems to depend on the theory relied upon for other pour-overs. A. Incorporation by reference, Section 392. Obviously, the incorporation by reference doctrine would not allow subsequent acts or writings by the third party to affect the testator's disposition unless the third party's power to amend it is itself viewed as an interest created at the time of the testator's death and incorporated by reference to the third party's document, which was in existence when testator's will was executed, thus incorporating the power of appointment over any asset that may be in the trust at the time of the exercise, including testator's property. B. Facts of independent significance, Section 393. Under the doctrine of independent significance, there appears to be no theoretical objection to the testator's disposition being affected actual events subsequent to death. In fact, a similar problem can arise in a pour-over to an inter vivos trust created by the testator himself. The inter vivos trust could have a provision authorizing someone else to amend the trust, example by power of appointment, after the testator's death. The Uniform Testamentary Additions to Trust Act, discussed infra, appears to cover this situation. The original version of the Act provided that the post-death amendment of the trust by the third party affects the property received by the testator's estate only if the testator will expressly provides for a post-death amendment. But what if the inter vivos trust had contained a special power of appointment conferred on a beneficiary? Would the exercise of the power or to modify the remainder provisions of the trust constitute an amendment not expressly provided for in the will? Does the effect of the power of subsequent amendment depend on whether the power is labeled a power of appointment or a power of amendment? Partly to remedy the problem, the Uniform Act has revised, and some state laws now allow post-death amendments in accordance with the terms of the trust as long as the will does not prohibit it. F. Uniform Testamentary Additions to Trust Act, Section 394. The validity of pour-over provisions is now clearly established in most states by pour-over trust legislation based on the Uniform Testamentary Additions to Trust Act. Basically, the Act validates a testamentary gift to any pre-existing trust evidenced by a writing, provided the trust is significantly described in the testator's will. Number 1, testator or third party's trust, Section 395. The pour-over may be to a pre-existing trust created by testator or by a third person, and the trust may be modified or in fact modified even after the testator's death, but see Supra, Section 393. Exam tip. If you see a pour-over on your exam, keep in mind that the doctrines of incorporation by reference and facts of independent significance have been used to uphold pour-overs, but also note that most states have enacted the Uniform Testamentary Additions to Trust Act or similar legislation, which validates a testamentary gift to an inter vivos trust created by the testator or another person, even if the trust is irrevocable or amendable, and even if the trust is amended after the will's execution. 2. Unfunded trust, Section 396. The size, character, and even existence of the trust corpus during the testator's lifetime is immaterial. Thus, testators often create living trusts with no assets, and by subsequent written trust amendments without testamentary formalities after the disposition of the assets passing under their wills. Number 3, life insurance trust, Section 397. The Act specifically validates gifts to either funded or unfunded life insurance trusts, see Infra Section 412, even where the testator has reserved all rights of ownership in the policies. Number 4, inter vivos trust, Section 398. Finally, the Act provides that the property bequeathed or divised to the pre-existing trust becomes a part of the inter vivos trust and is not held in a separate testamentary trust. And we'll pick up on Section D next week, the revocable inter vivos trust as will substitute, special problems. So we'll pick it up next week and we'll open it up for some questions and comments.
Hey folks, if you got a question, hit *8 on your phone. It'll show up on my screen here and I'll unmute you and give you an opportunity to ask Christian a question. *8, folks. We got any takers tonight? Well, Christian, I'm not seeing anybody. Oh, here we go. Trust Study 1.
Yes. Yes. Good evening. How are you?
Hi. Go ahead with your question.
Yeah. Christian, what? I didn't get all of that, but what is that? How does that relate to us in terms of the private aspect of trust application?
Well, this whole book, Gilbert's, is really, as I've been saying all along since we started going over it, is an example of what I call the black trust, which is the statutory trust. It is the public trust, operates solely on the public side, and is not being confused with the private trust. We're going to go over the private trust next, and we're going to do a comparison of Gilbert's black trust with the white trust, what I call the private trust. And that private trust, which we're going over next, is going to be that Lewin book, The Practical Treatise on the Law of Trust.
Okay. Are there any of these the testamentary aspects and the amendments? Is that any way tied into the Constitution?
Ties in with the Constitution? Well, as I see any of the USC code or any of the UCC code, including the Constitution or everything, is really a public trust. And anybody who swore a duty to that Constitution, aka meaning the employees of the United States, they have an obligation to that Constitution to perform according to good faith, because all of UCC and USC is a public trust to do good faith. And any breach of good faith, in other words, bad faith, is a breach of trust, breach of public trust. So that's how it ties in.
So it doesn't have an effect in terms of the amendments or anything like that?
Well, I kind of talked about last Saturday on the Saturday show, bringing out the points more of this public trust that is already in existence, and anybody who is in office in a public trust has a duty to do good faith. And anybody that doesn't do good faith, or they break a statutes and code, or UCC code, or they don't do what according to the Constitution says, then they're in breach of trust. And instead, that's where the real power of the trust comes in, because now you do an enforcement under trust instead of coming in under statutory claims at law.
And that would apply also to, let's say, public utility companies and banks and organizations of that nature?
Yes, because they have a duty to perform under the public trust policy. And they must perform according to a standard, and that standard is in good faith. And it's set up in the rules, being the U.S. Code and the UCC, because everything that happens today is really governed by UCC under Commerce.
No.
So what I'm trying to point out is we've got a public trust right there that they must perform to. If they don't perform to that, our power to take back the authority and the right is really come under trust and come at them at a breach of trust.
And we would come in as beneficiaries?
Yes, beneficiaries make a claim, yes.
And then those entities, banks and utility companies, telephone companies, do they take an oath to support that public duty, or is that implied?
Yes, it's an implied trust, implied public trust. Everybody is supposed to perform according to the statutes and codes. Everybody's supposed to perform according to banking laws. Everybody's supposed to perform according to UCC. Everything is there already in place. The public trust is in place. Now, when they don't do the duty of the public trust, they're in breach of trust. But nobody's coming at them under breach of trust, under equitable trust. They're coming back under, say, statutory.
Right.
They don't have any authority under statutory. You can't enforce a beneficiary claim under statutory at law. Because when you switch into equity, making a claim as beneficiary, now the burden or the onus probandi shifts to the trustee And the beneficiary doesn't have to prove up anything.
Right, because we make the claim that the trustee is in breach of trust.
So we're making two defects. We're coming back as against them under statutory provisions, which doesn't give you any teeth. If we would come at them under trust and on the equitable side as beneficiaries.
Now, once again, I kind of forgot. We're not gonna use specific language to say that we're forming a trust, but
this one's already formed.
Right. So when we come on the private side, once again we have to go on the public and then go back into chambers to get into the private. Is that what you're saying?
Yes, to get into equity.
Right. Okay. I mean, get into private.
Private equitable trust operates solely in equity.
Right.
If you get hung up at law and bring a claim at law, the beneficiary is probably going to have to prove his claim.
But once again, we have to go in on the public side. You know, they breached the public trust, but then when we prove our claim, we have to do the CCI, we have to do the protective order, and go into private chambers to resolve it.
Right. Coming through the public side is kind of like public notice, I'm here. But then we're going to go on the private side, and we're going to bring in the private side, but we're going to do that in chambers, and we're going to keep them separate. We're going to keep them segregated so we don't commingle those two trusts.
Almost like two separate jurisdictions.
Yeah. So the public side has been noticed, but the actual law is really on the private side.
Right.
Form, process, and procedure is in the public. Actual substantive rights is in the private.
Right.
But yet it takes two of them simultaneously to get a remedy.
And then what would that remedy look like? But we could compel them to correct their breach. We could use.
Yes, that's where the greater power comes in before they even breach the trust or the public duty. You could enforce them or enjoin them not to breach the trust, which is where I keep touting that's where the greater power is.
It's in prevention as opposed to waiting for the actual breach.
Correct. If it looks like they are going to breach, you could bring an action under trust in equity and prevent them from doing the breach. They're looking like they're selling the United States down the tubes. We need to come together and come at them and say, hey, no, you can't do that under a court of equity because you're going to breach the public trust.
So it looks like many of the financial dilemmas in which our country's in, credit cards, banking, all those type of instruments, if these companies are not doing the correct thing, if they're breaching the trust, then as you say, we can come together and, save our country from being sold off to all parts of the world.
Correct.
Very powerful stuff.
So that works on a macrocosm as well as a microcosm. If you had an individual case or a particular thing, say you had an issue with one bank that didn't do something, or even one government official. Same scenario.
That's a unique case because the government officials, say a so-called judge, are they not compelled to swear an oath?
Yes, but it's really, you have a confidence in them to uphold something. I don't care whether they swore an oath or not. I got a trust.
Because of their position.
Yes. And a trust is a confidence in the person to do their duty. What is the duty?
Right.
Operate under public policy. The statutes and codes, the way they were written. To do the House Joint Resolution 192 discharge on the public side. Not to breach anything under UCC.
And as you said before, when they're held to a higher standard, and by not complying with the trust or then they are monopolizing and then that's we have to go in and use the anti
Antitrust Sherman Act, yeah.
Right.
Which contains criminal charges.
Yes, exactly.
There's where our power lies. We're not taking full advantage of the power of the trust. We're being led under coming under, say, at-law actions under statutory provisions on the public side of the court.
Right. It just takes maybe more classes, more lessons, more people just to make that transition.
Right.
Because the awareness is building, but it's not where most people are at the moment.
Correct. I can tell that by some of the questions that people ask.
Of course. Right. Now, you said that most of the state statutes are public trust. Could you explain that? How does that work for like education?
Anything that's written into the state statutes or federal, it's being we the people. We have a confidence that these employees are supposed to be operating under a standard, and that standard would be these, say, state statutes. And that confidence, that's the trust. It's a public trust.
Well, okay, no, but in my view, the standard of education in the United States is going down, not up.
Okay, so now come in under trust and tell them, hey, we don't want you to breach trust. Now start coming up with some different standards. Let's start making it go the other way. So now we come in with a potential breach of trust and have equity enjoin them from breaching the trust.
I mean, we can take a person 16 weeks and train him into some super killer. Yet we can't take the same person and make him an excellent student in the same amount of time.
Yes, because all we're going to be doing is we're taking that person and teaching him some kind of reaction. And reaction doesn't involve any thinking.
True, right.
The other process involves thinking, and now we got a problem because most of us don't know how to think.
Don't you think that's by design, Christian?
Yes, because it's due to social conditioning or social brainwashing that drew primarily to the education system, yes. But, hey, who's responsible for that? We the people.
We are.
Yes.
We the people have allowed ourselves to be brainwashed and duped and desensitized and entertained by the media. And
we have the exact type of government that we've allowed it to become.
Yeah, that's a good point. Because people haven't taken responsibility like you've talked about.
Jefferson said, "He who sleeps on his rights has no rights." And I think it was Patrick Henry said that only takes for a few good men to do nothing for tyranny to abound.
Well, we have a lot of work to do.
Yeah, well, first part is recognizing what the problem is. And we've been off in the wrong direction too long. And the right path is really trust. Now, when we can start seeing trust every place, because that's what it all is, really, the relationship of trust. And it's very easy to turn it into trust, but it's not that relationship.
Well, in a way, also, seeing from the trust side, the notion of fair play or what's right or wrong seems to be easier to define.
Yes, because that would be, that's spelled out in the laws, in the statutes and codes.
Well, not only that, but, I mean, just basic things like, you can't be playing your radio at 1 o'clock at night on super high levels, disturbing the neighborhood.
Right.
That's just not, it goes against the social compact.
Right.
Now, unfortunately, it seems that we as a nation, I think as a whole, we have a new standard of what's etiquette or, what's fair. Like everything goes. We have no regard for other folks, it seems.
What democracy is.
Yeah.
It's rule of the few over the masses. Well, if we all get together and decide that murder is okay, well, I guess murder's all right then.
Exactly, because the majority rules, right?
Yes. Right.
And maybe in a way that's part of the reason why it's such a challenge for this movement to take off, because the mindset is in a democratic sense set that we can't be independent. We have to go wait for the masses to approve it.
Right. Right. Where's your standard at? Is the standard from the masses, or is the standard under something else?
Well, I think in many cases the standard has been forgotten or overlooked. It goes to what the majority says. That's what most people will go by.
Yes, thinking themselves to be wise, they became fools.
Yeah, right. Or like, we've abandoned our duty to be independent thinkers because it's easier to have someone else like one of those guys that do the surveys.
Yes, we've appointed foxes in charge of the hen house, and now we're complaining that, hey, all the chickens are missing.
Like the Nielsen ratings. Nielsen tells you everything that's right and wrong with you.
Yeah, so who was watching the foxes? That was our duty.
Right.
But anyway, I hope that everybody starts seeing more and more the power of trust, and that there are trusts in existence all around us that we're completely unaware of.
Now, especially in the readings tonight, it seemed that one section talked about layer trust, and also on the call last night, a gentleman was talking about a master trust having other trusts within that master trust.
Mm-hmm. Right.
And then that seems to be, he had a good view on that, and that seems to be what's really happening. We have master trust, and we have other trusts in that trust.
Yes, he was more on the administration of trust on the statutory side,
Yes, that's true.
But, we haven't gotten that far yet, so I've been laying down more thorough groundwork first.
Well, now, here's a question. The law of the land. The law goes with the land, right?
Supposedly.
Right.
Rights to stem from, all rights stem from land.
Right. Now, prior to 1492, there must have been some type of law standard on this land.
Well, who was here at 1492?
That's what I'm saying. The people who were here had a standard.
Yeah. So we brought our laws with us, but who was here before us?
Well, the Aboriginal people.
Right.
So do those two claims or law views merge, or is one superseded by force, or what's your view?
Well, that's apparently what happened. Yeah, we took it and imposed it upon them. Yeah.
Because the notion of owning land is foreign to the native view. You can't, sell
yes,
land.
that's kind of like the whole premise. Really, we're not supposed to really own anything. We're supposed to be administering a trust and for the benefit of some other third party. But we're not all looking at it that way. We want to possess it and own it.
Right. Because if you go back to feudal times, the king parceled out estates, and those people parceled out segments of those estates on down the line.
Yes, notice what it said back then. It said the king was in by his cheat, and his cheat is he cheated.
Who did he cheat? The people or nature?
Well, it says there that he should not have been over the people because due to his high prerogative, he shouldn't have been in that position.
You mean the position to parcel out lands?
Yes, on page 2 of the Lewin book there, it says, nor was it competent for the king to sustain the character of trustee, for it was thought inconsistent with his high prerogative that he should be made responsible to his own subject for the due administration of the estate.
Right.
So he couldn't be trustee, but now they're beneficiaries, they're claiming. So they got around it.
Right. He wasn't trustee. He could have been, but I'm saying I think he was the grantor. He said, look, I got the army. I'm saying I'm going to give you, Christian, I'm going to give you all this stuff over here because you served me well.
Yeah, but where did he get it from?
That's what I'm saying.
They have the right to transfer it.
I don't know. That's what I'm asking. Right.
Yeah, that's the thing. Where did it all start from? It was granted by God, really.
Exactly. That's my point. Exactly right. So we have the metaphysical law, and then we have the practical law, where the practical law is backed up by force of weapons.
Yes, whether it's done in righteousness or unrighteousness. That's the question.
So then bringing back to my question about the law of the land, really the law of the land is the law of the sword.
Yes, because that's what we force everybody to do, whether it's right or wrong.
And then now how does that fit into our concept of going into equity?
For enforcement?
Well, yeah, because we're seeking equity, where we can't get remedy in the side, the public side, which may be hostile, and so now the hostility is backed up by, the weapons, and we want to go to the other side, and what's backing the equity up, or as powering them to comply.
Well, there again, if it's a breach of the equitable principles, then we've got total chaos then.
So basically, we're standing on principle.
Yeah, if they're not willing to go by the rules that they've established, then their whole deck of cards is going to come down on them.
Well, there is some evidence that that's the case at the moment. That they, whoever they are, refuse to follow their own rules.
Correct.
So again, the work you do is important because through the work, we perhaps can, salvage the country.
If enough of us would become knowledgeable and come under the understanding, yes, and stand as a group. Because when it looks like they're operating against public policy, public view, when it's too exposed, they're not willing to move against that.
Right. So that's why they work against. They're like lions in a herd. The lion doesn't pick out the strong; he picks out the weak one, and they corral that. They hunt that one.
Well, they'll test the whole group also. They'll turn the hot water up until it becomes too hot, and then they'll back it off a little bit, and then they'll turn it up, and they'll turn it up until they get you conditioned to the hot water. Finally, nobody realizes, hey, the water's boiling, and it's too late.
Right. We're all cooked frogs.
Uh-huh.
So, thanks for doing what you're doing.
Thank you.
Those are all the comments I have right now.
Appreciate them.
Yeah, those are great questions. Thank you. And the caller, if I can say this right, San Greta Grotto. If I can get you unmuted here. All right, go ahead. You've been unmuted.
Hey guys, how you doing tonight?
All right.
Welcome to the call.
Great. This is Dan from Southern California. I had a question about been kind of looking at the Amish and their law form. They're operating under an ecclesiastical trust, using the scriptures as their law form. How do you think they established standing using their methods way back when?
I think that everything is confirmed by your actions. They don't act in public.
Right. They certainly don't act in public.
Yeah. If you don't do the actions in public, you don't have the obligation responsibilities.
So I guess really what we just need to start doing is doing private things. I've put up a private mailbox next to my public mailbox. I'm researching, rural routes and meets and bounds, and just trying to switch over. So I guess what we just need to do is just start physically behaving like private people.
Yeah, well, in a way, yes. But trouble is, the colorable titles that I need to gain all the products that I'm used to has to be gotten through the public side.
Okay, so that's the
problem.
trick.
So now instead of isolating ourselves from the public side, we need to learn how to utilize it.
Yeah, it's
how to keep it separate, though, but not commingle it.
Like you're one and you're learning how to walk again. Don't have those muscles. Also on these, I've been reading these trust indentures on these mortgage-backed security things that you find on the SEC website. And, if you need a grantor to form a trust with intent, purpose, and the parties, I don't see how these trusts are legitimate. How does another trust have intent and purpose as well? They call it an issuer, but it's behaving like a grantor when they pass over these notes into another trust, an indenture trust. I don't see how a grantor stepped in and formed these trusts with intent and purpose and legitimate parties.
Well, it could be a spillover trust.
Okay, because nowhere in these indentures do you see any mention of a grantor, and all I could find was that they create another trust and they call that an issuer that holds the notes and then transfers them into the actual trust indenture, where these promissory notes get pooled or whatever. And I don't see how a legal fiction can have intent and purpose.
Well, that's where they modified it way back when they said, they kept changing things on the rise and progress of trust out of the Lewin book, because how could a corporation be capable of confidence when it didn't have a soul?
Exactly.
But now they've changed things. They've made it okay for corporations to be, because the corporation is a person, a legal entity.
Right. But it still can't express an intention or a purpose.
Right. But it could be construed by an implied trust.
Right. Okay. Well, that struck me as odd. I don't see how any of these trust indentures are valid. And also, these things happen in reverse. These indentures are created before these alleged loans were supposedly funded. And how do you transfer trust property at a future time? According to Gilbert's, you can't do that. You need to transfer.
By contract?
You're right. Oh, by contract. Okay.
Yes.
All right. Just some stuff that struck me when I was reading these ridiculous indentures. I mean, you got to have a Black's Law translating every damn word. It's like written in Martian. Yeah, we have to know 2 foreign languages, or 2. We have to know our own language, English, and then we have to know the legalese speak of a law dictionary. Really. Like Bill Clinton said, depends on what the definition of is.
Correct. That's right. He was right.
He was right. He was absolutely right. So that's all I had. Just some comments.
Okay. Thanks.
Thank you.
Anybody else got a question tonight? Hit star 8 on your phone. Pretty light on the questions tonight, Christian.
Oh, that's okay. I need a rest.
I hear you. Well, that's all we got for tonight. Oh, looks like we got one jumped in here. Jordan News 2. Go ahead. You've been on
Right. Chris, now, are you doing the Saturday show still? Is that still on? How does that work?
I didn't get your question. Say again.
Saturday. Do you have a show Saturday now, or is it
yeah,
different?
I have a Saturday show. It's the number is same as on the Tuesday call also, 712
Right.
432 0075, and the PIN access is 917 030 pound.
And what time is that show?
It's at 9 o'clock Eastern time.
Okay. And do we have access to any of the NTT documents now?
Not till I get the website back up.
Okay. And where the gentleman from California who was talking, from where do you get those documents from?
I think you got them off the SEC. They're publicly available to anybody.
The FCC?
Yeah, SEC.
Oh, SEC.
Securities
Okay.
Exchange Commission.
Right. Okay. Right.
I think if you do a Google, you could also get them off of Edgar, the site for Edgar.
Uh-huh. And under what? Mortgages?
Probably, like you said, indentures or security instruments or security agreements.
Okay, so because they're mortgage-backed securities.
That's right.
Okay, all right. Now, also, we do a lot of talking work with the Gilbert's Trust. But what about? I understand the UCC is a very valuable tool as well. Are there any particular aspects of that other than the whole UCC we should be looking at? Should just stay up as a parallel study?
Well, I was just revealing some things I saw in the UCC the last week that really how we're coming into court and we're thinking of, court's totally different from what we've been really accustomed to. It's really the bench is the bank, and
yes.
We're bankers going to court to do banking. And really, we're getting presented with these mortgage notes for payment, but yet we're not cashing them, and we're falling into a dishonor because we're dishonoring the presentments, and then they're reaching to the secondary contract, the security agreement, and doing the enforcement off of that.
And which one of the UCCs is that?
Well, if you study the 3-200 series, the endorsement sections.
Yes.
There's a lot of stuff in there that really we should be doing banking, and all you have to do is think about what happens when you go to a bank and you try to cash one of your checks. The first thing I do is they're going to ask you is, do you have an account here?
Right.
And they want to flip over the check and they want to look and see if you endorsed it. And if you didn't endorse it, they're going to give it back to you and ask you to endorse it, and then they want to see 2 forms of identification.
Now, by endorsing the check, does that make it makes it negotiable?
Yes.
Now, is that what we want to do?
With the promissory notes, we're not looking at it. That's what they're doing. They're doing a presentment to you for cashing under 3-501, but you're not cashing the instrument, so you're falling into a dishonor under 3-502, and they're going to certify it under 3-505, and then you're going to be in dishonor, certified, and then they're going to go to the security agreement and finish the foreclosure. But what you should have done is you should have asked them to endorse the instrument so you can cash it.
Oh, ask them to endorse it, right.
Because when you go to a bank, what does the bank ask you to do? Endorse the instrument.
Right, so that's 3-200 series.
Yeah.
And if we don't do that, we don't ask them to endorse it, we fall into the 300-505 series.
Yes, right. So now when you ask them to endorse it so they cash you, if they don't endorse it, well, Your Honor, motion to dismiss. I made an offer for settlement here, and they won't take it.
It's the same thing with a credit card bill, utility bill, phone bill, mortgage.
Yeah. Same thing.
All those instruments, if they send us presentment, if they're unendorsed, and we make them an offer to settle based upon the endorsement, and they refuse, then we are in arm.
Right. Now, if we don't fall into an endorsement dishonor, because there's one section, let me see which one it is. It's 3-604. Oh, so I know which one it is. It's 3-504. Yes, 3-504. Excused presentment and excused notice of dishonor. So we have a legal right. We're excused from the presentment. We are excused from the notice of dishonor from the fact that there's a lack of endorsement because we asked them to endorse it.
Now, when we do something like that, that would be...
Now they can't enforce the instrument. They can't enforce the security agreement.
Right. And that's for all those type instruments I spoke about.
Yes.
Well, now, how do we do that? Do we do that as a trust? Do we convey that to the?
No, that's not trust at all, really. Unless you want to look at all of UCC, is that they need to be doing this because if they're not, because this is a public trust anyway. Now I can get them for breach of trust if they don't do this.
Right. So we don't have to notice them the fact that they're in breach and show them how to correct it, or.
Well, yeah, you would have to give them notice that they were in breach if they breached a trust. Yes, you can.
Right.
You can actually.
So here again, you know, what I hear you say is that we don't want to let them know we're forming a trust because
don't have to. This one's already been formed.
I'm sorry. Yes, right. You're right. It's already
been formed.
Right. So now we can just say that you're in violation of public trust, and to remedy that, we suggest we demand or command that you endorse the presentment.
Yeah, and then you're excused under 3-504 if they refuse, and you can't fall into a dishonor, and they can't enforce the security agreement.
And why would they not want to sign it? Because we can negotiate it.
The last party on who makes the signature is the liable party.
Okay.
And the attorney, they don't want to be responsible for the bank, so they're not going to sign in an agency capacity, are they?
No,
and if
they're not.
they did, I could challenge it immediately and have them prove that they had agency.
Right.
Otherwise, they'd be operating and making a fraudulent endorsement. It would be conversion.
The
bank is the one who has to sign. If they can't endorse it, they'll have to endorse it. So let's say they endorse it. All right, now, you took your check to the bank and you endorsed it. Now, what is the next thing the bank asks you?
ID.
Identification.
Right.
Now, let's see the identification, Mr. Bank. What is the identification that you want them to produce?
Well, they have sufficient funds.
No. Like they're presenting the instrument for payment to you.
Right.
And you're going to ask them to endorse it, and they endorse it, and then you're going to do what? You're going to ask them for?
Identification. Who are they?
Yeah, no, it's not identification. Who are they thinking? But yeah, it is. What gives you the authority to have the right to collect here?
Oh, okay.
What is your identification?
Oh, what's your delegation of authority, you mean? In other words, like you're talking about a mortgage case, for example, right?
Yeah, so they're trying to enforce a note. What they're doing at the bank, they're throwing that note at you. Is that your signature? No, they just want you to validate that you're the bank. Yeah, that's my signature. Okay, now, are you presenting this for collection here today? Do you want me to pay the instrument? Okay, endorse it.
Right.
If they don't endorse it, how am I gonna? If I made an offer to pay it, if they don't endorse it, I can't pay it. Legally, I can't pay it. I got a legal right.
So that's the same, similar to what the gentleman last night was saying. You know, where you compel the opposing party to make the payment or not, and if they fail to make the payment, then there's no claim.
Right. So I made the offer to cash the instrument or make the payment to them. But if they don't endorse it, I don't have to make payment. I have legal grounds not to. And I'm excused from a dishonor at that point.
And
so let's say they sign the instrument, the bank signs the instrument, not the attorneys. The bank signs the instrument. I get to compare the signatures. If the signature on the back matches the one who the instrument was paid out to.
Right.
So UCC 3-206 was talking about restrictive endorsements under C1.
Mm-hmm.
C1 says a person other than the bank who purchases the instrument when so endorsed converts the instrument unless the amount paid for the instrument is received by the endorser or applied consistently with the endorsement. So in other words, if a person other than bank, that's you, who purchases the instrument, that's the identification you want to see. That's
Right.
the ID you ask them for. Show me that you purchased the instrument and you have a receipt and that you received the payments. So that would be the receipt of the purchase of the instrument. That is the proof that they are the owner of it as well as the holder with an enforcement right, or else it's conversion.
Now, something that happened. I was helping a friend with a credit card situation, and we wanted to know, it was a series of banks involved. The Washington Mutual was his original bank, and they went under, and this third party, this debt collecting agency, had a spreadsheet with all the charges on it. And they brought that to the court, and the court accepted it as proof of, that they had control of this, of the debt. But I mean, it's just a spreadsheet. There's no note on the Washington Mutual letterhead or anything. How does that work? There's some case they cite that allows them to do that.
Yeah, they didn't do what they're supposed to on their part to dispute the fact and make them prove that they didn't really have the account.
Well, we asked them to prove it, and they said, "Oh, I don't have to do anything. It's right here."
They don't. They just have to make the acquisition. Now it's up to you to dig up the evidence that they don't.
Oh, okay. Well, that's
backwards than what we think, how we've been trained to think. Everything works backwards in that room.
Wow. So they can just do that just by claiming it.
Yes, it's up to you to bring up evidence to rebut that.
That's like saying that we're the trustee.
An NOI, hey, I don't know that. These documents are fraud. Okay, that's a claim. That's an NOI. If you don't have an SOI, a material fact, to support that NOI, within 30 days, you're dead.
So we'd have to find some way to prove that, in fact, they didn't have it.
Okay, that's what discovery is for, because now you can compel them to do certain things, produce certain documents, and when they can't, then you can start destroying affidavits and the testimony because there's no competent fact witness there.
Well, that's what we fell down. We didn't do a discovery.
But see, in this scenario, I'd say, okay, where's the instrument? Present it right now, and I'll pay it. Now, once I said that, they can't foreclose because I made an offer to pay it right there in open court.
Right, but they have to endorse it.
But yeah, they got to produce the instrument too.
Oh, I mean the original contract.
Well, the original, say the note, if it was a note.
Okay. That's the notes for the mortgage, and the contract or agreement would be for the credit card.
Yeah, let's just say it's a mortgage, but on the mortgage you got a note. Well, they're presenting the note for payment. I'm going to have them endorse it, and then I'll cash it. But first, after you've endorsed it, I get to compare the signatures, and I have to ask you for identification, and your identification is prove me the chain of assignment trails that proves that you purchased the instrument and have the right to enforce it.
Wow. I mean, that's over thousands of people. You could help with that.
Yeah, now I don't fall into a dishonor until they prove the fact.
Right. And that's what happened to my friend and I. We had to prove it, and we couldn't, so therefore they had the upper hand.
Yeah, because now you fell into a dishonor because they made the presentment. You were in a dishonor. They get to enforce the contract, the security agreement.
Because we didn't do the discovery claim.
Right.
Well, live and learn.
You didn't do the discovery. You didn't do the payment.
Right.
You could have asked for the identifying information.
Well, we tried that, but they said, well, that's irrelevant now because we have the right here because you didn't, it's like you said, we didn't have any thing to rebut their claim.
Yeah, you need one material fact evidence to create a controversy, and then it goes on to a trial. Then there would be issues that are in disputes, and now they can't do a summary judgment, say.
Right. Well, we settled out outside of court, and the judge or the banker confirmed the out of court settlement.
Uh-huh.
Well, okay. Thanks a lot. I appreciate it.
All right.
All right, we got another caller here. Tackfire. Tackfire, you've been unmuted. Go ahead.
Yeah, Christian.
Yeah.
Is there a UCC manual for all the codes that we can purchase? Because I've read those in certain books that you're mentioning, but is there a UCC Bible like the Internal Revenue Code? And second, I like to ask is the number for Saturday. You were going real fast and my mic fell away from my ear. I like to hear it again.
Okay. The phone number is 712-432-0075. And the PIN access is 917030#. So that's at 9 p.m. Eastern Time.
Okay, can you answer my second question?
As far as UCC, they make some little books that kind of explains it. I forget what the title of it is. It's put out by the the bar, I believe, too.
Okay.
They're kind of explanatory, but really, the book itself with the official comments is the thing that really holds the key.
Okay, but what I was saying is just like the Internal Revenue Manual, I picked that up a couple of weeks ago, and it has everything in there on all the codes. I'm asking, is there a UCC manual that lists all the codes other than some of the books that we're buying or purchasing that lists those same codes that you're talking about? If I want to know, if I just want to research the UCC codes, is there a book? Is there a Bible for it, the UCC Bible?
Yes, it's called Uniform Commercial Code.
Right.
Official text and comments.
Where would we get that? Is that with Western or?
Thomson West. And
Okay.
I believe Anderson makes a version also.
Okay, and thanks. Yeah, that's exactly what I need.
But make sure you get the one with the official comments.
Official? Okay, I'm writing that down as we speak. Thanks, Chris.
Also, somebody was telling me that there's a cheaper version if you get the debtor-creditor relationship book. That's got UCC in it as well as debtor-creditor.
Okay, that's good.
Yeah, commercial and debtor-creditor law. That's Foundation Press.
Yeah, okay, Tim, I got that. I sure appreciate it.
Okay.
One more question from George.
Yeah, I was going to say, I was going to call you and let you know that's the title of the book, Commercial and Debtor Credit Law, Foundation Press. I paid $45 for that.
Right. So it's a little cheaper version. It's got both in it.
Which is half of the price you would pay for the UCC.
Yeah. Can you hear me?
Yes.
Hello?
Yes,
yeah,
okay.
under that, this is Tactile again. Under that debtor-creditor, where is he getting that book at?
Oh, I got it at a law school bookstore, but it's under Foundation Press. Foundation Press, it's a subsidiary of Thomson West.
Okay, Foundation Press. Okay, yeah, I need to know where to get this stuff. I want to go ahead and get those. I appreciate it.
You're welcome. Okay, well, thanks again, Christian. I'll be with you on Saturday. Peace.
Thank you.
Well, that's all the questions we have for tonight, unless somebody wants to jump in here.
Okay, we'll call it.
Yep, 9:45. We'll shut her down for the night. Christian, thank you. It's always a pleasure. Folks, thanks for dialing in tonight. We will reconvene next Wednesday night, same time, 8 p.m. Central. Have a great week. Have a great weekend, and we will talk to you then. Good night, everybody. Good night, Christian.
Thanks, Matt.